All right, so now today we're going to continue in talking about the intersection between the industrial side of psychology and the legal issues that might arise. Okay, but now we're going to talk about some more specific laws. So the Fair Labor Standards Act of 1938, which came up during the Great Depression, was clearly designed at a time when labor unions were beginning to receive power, because of course prior to 1938 the American workers had no rights, none at all. The companies would just, you got a problem, you're fired. I mean, it's just, you have no ability to say anything, no complaints. Think Charles Dickens kinds of things, you know. It was this type of thing that made Karl Marx really introduce communism and denounce capitalism. So clearly, this is the beginning of workers gaining some kind of rights, and it creates overtime for 40 hours a week. It prohibits, it set rules for employment of minors and things of this nature. Hmm? So here's some of the major laws, and I'm going to talk a little bit more about each of these. So I'll let this slide all for you. Okay? So the Equal Pay Act attempted to address gender discrimination in employment, in particular in pay. And so it's illegal to discriminate in pay and benefits on the basis of gender for jobs that are equal. Okay? And the problem with this line, and it's a beautiful line, but the word equal has been incredibly discussed. There's a lot of disagreement on what equals equal. And so one of the Supreme Court cases which did play this out found out that a male orderly who was given an additional responsibility to flip patients, because males tend to be physically stronger, so they were given a physical task that the women were not, and the hospital was paying them more money, and the Supreme Court came down and said these differences between the occupations must be significant before they are different occupations. But still, this word equal has been quite difficult to work with. The Civil Rights Act of 1964, and you can see the actual title of the Civil Rights Act. It's just this crazy paragraph long thing. But the Civil Rights Act did in fact create all kinds of, well, civil rights, and it defined discrimination and made it illegal to discriminate in terms of voting, housing, employment, things of this nature. But in terms of the I.O. course, it laid out it was illegal to discriminate based on race, color, religion, sex, or national origin when it comes to an employment. It also, by the way, laid out sexual harassment, that sexual harassment is illegal, and it distinguished two clearly different types. That is, quid pro quo, which was this for that. If you give me this, then I will give you that. Okay, versus a hostile work environment, which would be more of the lines of, the stereotypical hostile work environment is, you know, a bunch of men, and there's a few women that work in the company, and a bunch of men, and they make dirty jokes all day long, and put Playboy centerfolds on the wall, you know, this kind of environment. Okay, so even though there might be nothing that is exclusively quid pro quo in sexual in this way, it's just the environment itself is hostile. Okay? Sexual orientation has been much more recently protected under the Civil Rights Act. This is quite new, as you can see in these couple of much more recent Supreme Court findings. A person, I don't know who it is honestly, that was fired when they expressed interest in creating a gay softball league. Or here at a funeral home, there was a worker, and she had been male for years, and then she went in for gender reassignment surgery, and she sent a letter to her employer, hey, get ready, I'm going to be back as a woman, and they fired her. Okay. The ADA is similar to the Civil Rights Act, but the Americans with Disabilities Act lays out it is illegal to discriminate against a qualified individual that otherwise has a disability. And now a qualified individual is one that is able to perform the essential functions of a job. So the top corner up in here gives a good example. If a job involved daily, routine, heavy lifting of boxes, then it would not be illegal to discriminate with somebody with a bad back. But if a job maybe once a week involved moving printer paper from one shelf to another, and the employee could not perform this function, but you could quite simply and easily have somebody else perform that function once a week, then heavy lifting is not an essential function of the job, and therefore a candidate with a bad back would otherwise be a qualified individual. And so employers are required to make reasonable accommodations. And in this last example, a reasonable accommodation is to have somebody else come in that one time a week when you need the printer paper moved and have that other person do it. Okay? So we find that reasonable accommodations is another loaded word, kind of like when it was in the Equal Pay Act when we said the word equal jobs. What is equal and what is reasonable is clearly in the mind of the perceiver, okay? And so what the Supreme Court, in order to sort of clarify what do you mean by reasonable accommodations, they've laid out the concept of undue hardship. And reasonable accommodations do not cause undue hardship on an organization. But even undue hardship isn't clearly defined. But the idea is, I'll give you a clear example that does create undue hardship. So you've got a person with a disability that is otherwise qualified, but because of the way the equipment in the factory is set up, it would cost, $500,000 to readjust the assembly line, which would disrupt the performance of other workers on the assembly line. I mean, that's undue hardship, okay? So we find that this idea of undue hardship, again, though, is subjective for sure. Okay? There's been some more recent updates to the ADA starting to expand disability to include mental disabilities as well. It's a work in progress. Check back in another 10 years and we'll see if the definition of disability has stabilized. But just like with any hypothetical construct, the operational definitions will differ depending on who you ask. Okay? The Family Medical and Leave Act, the FMLA, it's a start. It's pathetic. It is really pathetic relative to every other country on the planet. Okay, but it's better than we used to be. Absolutely. In the past, if a woman was pregnant, you could fire her for being pregnant. Done. Okay, it was just straightforward. So the FMLA allows for employees to take unpaid leave for 12 weeks. And I mean, the reason this is so pathetic is, if somebody is relatively poor and they're pregnant and it's about time to have a baby, you can't take 12 weeks off. Who can afford that? Not only are you unpaid for those 12 weeks, but you're now getting all those bills from the hospital, all right? You got to be kidding me, okay? So most other countries on the planet involve paid leave, much more than 12 weeks. I mean, it's crazy. Check out Wikipedia, and they got a great page on around the world family leave laws, and it's just, even like Zimbabwe does better than we do. It's just horrendous. Okay, now the Family Medical and Leave Act then stipulates that not only do you get 12 weeks of unpaid leave, but the employer must bring you back in the same or an equivalent position. And this is also problematic because if a position is in fact critical to the running of an organization and somebody needs 12 weeks leave, you need somebody to fill that position. So you train somebody in, you bring that person in, they perform that position, and now the original employee wants to return, and now what do? You can't replace the person you just put in the position. It can be problematic. It can be. And so, just like the word equal and undue hardship, equivalent is Very difficult word to define. Okay? Extended for the families of wounded soldiers. Yeah, okay. Blah, blah, blah. Okay, so that's what we have for the intersection between the legal system and the I side of our course. All right? Have a good day.